Partnership are a unique business relation that didn't require a written agreement, and both Ma and Za are aware that it is not necessary for them to have a written agreement to establish a partnership at law. However, Ma thought that it is best for them to formalize a partnership agreement. So, the purpose of today's video is that we are going to discuss and explain to you why Maza Corporation should not have a written agreement.
I am Nur Ain Ashikin binti Abdul Razak, number matrix A158576, humbly express my thanks for your interest in the Maza & Co. Chartered Accountant case study. I would like to begin by saying that the partners in Maza & Co. do not need a written agreement. Referring to the case, Maza & Co. were in excellent condition of financial and business structure. Because of that, we are strongly agree that Maza & Co. definitely do not need a written agreement. On top of that, there are numerous reasons for Maza & Co. clearly not needing a written agreement. First is the cost of the agreement. As we all aware, written agreement consume additional costs and extremely expensive to develop. The written agreement is the contract between multiple parties that is legally binding. Practically, written agreement not merely provide for the specific stipulation of the partners with regards to their contributions, rights, duties, liabilities, penalties, and profit or loss among the partners. To be stressed, the agreement must be legal advice and stamped for it confidential. As for instance, the cost of agreement include the stamp duty and other legal fees. In order for the agreement to be legitimate and be applied in court if any issues arise later. Furthermore, the stamp duty was compulsory or mandatory to items in any agreement, and the objective of stamping contract to provide the partners who signs the agreement. In addition, the cost of attorney was too expensive. What is attorney? Attorney is a person who is legally qualified and licensed to represent a person in a legal matter such as transactions or lawsuit. Why do we need an attorney in a structured partnership agreement? A formal partnership agreement must be addressed any issue that may leave later. Therefore, the guidance from attorney are highly recommended due to help with the process of developing partnership agreement and to avoid unclear and incomplete language in agreement. Thus, getting an attorney to help them with the process of preparing their partnership agreement will cost them quite a tons of money. Besides, Maza & Co. already on the structured partnership business. Therefore, they do not need any written agreement. On the other side, Maza & Co. should spend more on employee benefits in order to catch their loyalty towards the partnership instead of focuses on these expenses. Considering that the turnover was highly in the Maza & Co. partnership. Besides, Maza & Co. are still debating on employees' bonus in purpose to boost their employees' motivation. Therefore, Maza & Co. clearly has to ignore the cost of partnership agreement because it was too expensive and incurred more costs, as well as Maza & Co. need to consider other expenses. From all the justification above, we are firmly and vigorously agree that Maza & Co. do not need a written agreement.
Hi, I am Nida and I will move to the next point. Why Maza & Co. need a written agreement when they can use a Partnership Act formulated by Malaysian government in 1961? Partnership Acts are a default agreement of partnerships. Every partnership must have a registered under Partnership Act 1961. In addition, Partnership Act will prevent companies to spend a lot of money on agreement and can focus and develop their company. In other words, Maza & Co. can focus on expanding their business or develop new strategy other than spend money on agreement that surely will take time and money to draft and implement. Partnership agreements are always spoken as the advantage in scope power of partners in partnerships and the liability of partnership. However, Partnership Act has covered the scope under Section 7 that says a partner who is doing his job in terms of bona fide and his action will bring more revenue or his action will help the companies more progressive and develop. Hence, he has the right to make that actions and the partnership is usually taking the same action if that situation occur. Therefore, the partnership is obligated and liable in whatever his actions are. This will help and bind other partners to hold the obligation together in this situation, also avoiding the partners being passive and running away from dependency. And for the liability of partnerships has been explained in Section 11 in Partnership Act, which means that every partner of a firm is liable together with other partners for all debt and obligation the firm that he did when he was a partner. And after the death of his estate is also liable separately in proper administration of the debt and obligation, as long as it is not explained but is subjected to payment was previously a separate debt. In other words, partners are liable in whatever action he takes and decision he agrees to, as long as he is a partner, and if anything happens, his asset will cover the partnership losses and together with other partners. So, what we can conclude in this point is, using partnership agreement, partners can avoid from being dependents. However, using Partnership Act 1961, partners will bind and help each other until the partnership dissolves.
Next, we're gonna look at the next reason why should Maza and Co. do not need a written agreement between them or partnership agreements. The company can use Limited Liability Partnership Act 2012. What is Limited Liability Partnership Act 2012? The Limited Liability Partnership Act, LLPA, is an act to provide for registration, administration, and dissolution of limited liability partnership and to provide related matter. A LLP is a body corporate and has legal personality separate from that of its partner, which means any change in the partner of LLP does not affect the existence, right, or liability of the LLP. The limited liability partnership may be formed for the carrying on a professional practice. Professional practice means the practice of a chartered accountant and advocate and solicitor, and the last a company secretary. Maza and Co. can use this limited liability partnership since the Maza and Co. is a firm of chartered accountants. The limited liability partnership is a business vehicle that integrates the advantage of limited liability of a company and the flexibility of the partnership, such as for organizing their internal composition and operating as a partnership. The limited liability partnership is a hybrid version of conventional partnership. The conventional partnership has unlimited liability, which means when the firms have to settle its debts or fines, the owner asset can be used to pay all the debt or fines. A conventional partnership can convert to limited liability partnership if and only if the limited liability partnership partner to which it is to be exchanged consists of all such conventional partnership partner and no one else. Therefore, Maza and Co. can convert to limited liability partnerships due to the Muhammad Amir and Zainal Ali being both conventional partnership. In limited liability partnerships, only partnership assets can be used to settle all debt and fines. The limited liability partnership is more cheaper than partnership agreements and more effective in controlling the liability of a partner. The limited is good to both partnership Muhammad Amir and Zainal Ali because it protects personal asset from liability of the business. This is because the limited liability partnership are a separate legal entity to the member.
Next, I'm going to present point 4, profit and loss. For sure, everyone knows that profit and loss is determining the firm's income, and every partnership needs to distribute the profit and loss to each partner. Based on Section 26A Partnership Act 1961, all partners have the right to share the same average capital and profitability of the business, and it should make a fair contribution to the loss, equally any capital loss or otherwise suffered by the firm. The distribution of profit and loss is always using the ratio 50-50 or equally based on Partnership Act 1969. However, the ratio can be changed based on partnership agreement. For Maza and situation, the distribution ratio of profit and loss is at 50-50. If the ratio is being changed due to the writing of agreements such as 60-40, 70-30, it might lowering the motivation of the partner that having the less ratio. It is different when the ratio is at equal 50-50. The both partners will feel motivated and obligated to make the best on behalf of the partnership to make a lot of profit, so that each of them can enjoy for their hard work equally. Next, if Maza and Co. face losses, both Ma and Za will contribute in losses and vice versa. If Maza and Co. gain profit, both of them will obtain the profits. Hence, the profit and power in decision making were highly affected in efficiency of the workers. Based on Maslow's hierarchy of need, show that people need esteem at stage 4, which means that the need of involving feeling valued by others, including feeling that the achievement and contribution that have been recognized by other people. On the other hand, the contribution in profit and losses help the partners in efficiently working together, even though they have to go through hard time facing the losses and problems. Our group decide to not making a writing agreement regarding on profit and loss matter for Maza and Co.
Next, I'm going to clarify why it is not necessary for them to have a partnership written agreement. One disadvantage of having a written agreement is that they may have an unclear or incomplete language. If a contract does not lay out the relationship between partners properly, the provision that they thought have been enforced may not be incorporated in the actual contract. Hence why, when a dispute arises, the court system may have to determine based on the intent of the contract and the terms and conditions, but not based on the parties or partners who signed the agreement. Therefore, it is very important for the contract language to state clearly the parties or the partners' intention, requirement, responsibility, and the understanding of their business. Even with one unclear word or ambiguous phrase may lead to a contentious litigation. For example, a contract language related to identification or a compensation for harm or losses. So they have to beware of an unfavorable language such as consultants shall defend the identified parties against any claim which may potentially give rise to the indemnification of the identified parties, even if such claim alleges that the identified parties are wholly or partly at fault causing the loss. So what I'm trying to say or highlighted here, the even if or wholly or partly at fault causing the loss are the unfavorable language that they have to beware, because if they are accepting this such statement, which means that they are accepting a complete responsibilities and liabilities of such claim even though they are only partly at fault. Thus, it is very risky for Maza Corporation to prepare their own partnership written agreement, since the statement might not be right and there is a high possibility for them to be misinterpreted, and a poorly worded contract are way worse than none at all. That is why, when the partners are negotiating a contract with other partners, all of them must take a special care to avoid any ambitious or uncertainty in a contract language.
Assalamualaikum and salam sejahtera. My name is Nur Afrina with matrix number A161901. Now, I'm going to the second point of the disadvantage if Maza need a written agreement. But make sure not to confuse that cons of need of written agreement is similar to the advantage of do not need a written agreement. So, the reason number 5, why Maza & Co should not need a written agreement, because to make a written agreement, it takes time and also limits flexibility. Otherwise, by not doing a written agreement, Maza & Co save time and has a flexibility when they need to amend or revise their agreement. For example, oral contracts are quick and easy to implement for both parties. It will not take much time and cost very little for both parties when made for each contract. As we know, to make a written agreement, it takes a lot of procedures such as getting a lawyer and also stamping duty. Besides, a long contract also may require thorough review by lawyer. So, to avoid time investment, Maza & Co should not need a written agreement. Moreover, in the case also stated that partners were too busy with the expansion of their business. So, to avoid delays in workload, again, we want to stress that Maza & Co should remain as oral agreement. Apart from that, by not doing a written agreement, it is easy and flexible for them to modify the agreement based on the unexpected condition and also circumstances. Written contracts are not always simple to draft and also to amend. Formalizing an agreement also put restriction on Maza & Co.'s ability to operate flexibly in the future. For example, let's say Maza & Co. has signed a contract that each partner would service their own client, with the division of the total clients with ratio 40-60, then it creates clear rules on each partner's duties. In contrast, the informal agreement gives both partners greater flexibility in their roles. For example, maybe one day they might need other partner to handle some of his clients. So now, we have come out with our decision and we are strongly agreed that Maza & Co should not need a written agreement. Thank you for watching.